question, l'audience de la Cour pénale internationale est ouverte. Veuillez vous asseoir.
Good morning, everyone. Could the court officer please call the case?
Your Honor, situation in the Central African Republic in the case of the prosecutor versus Jean-Pierre Bemba Gombo et al. Case number ICC 01050113. For the record, Your Honor, we are in open session.
Thank you. I ask for the appearances of the parties. First, the prosecution, please.
Good morning, Your Honors. My name is Fabrizio Guariglia. I'm the Director of Prosecutions in the Office of the Prosecutor, appearing today due to the absence of our senior trial lawyer in the case, Mr. Cueco van der Poel. Appearing with me today are Ms. Olivia Strauben, Ms. Brichel Rege, and Ms. Priya Narandan.
Thank you. And for the defense, we have 3 defense teams here. I think I should start with Mrs. Taylor, please.
Good morning, Mr. President, Your Honours. My name is Melinda Taylor. I am appearing on behalf of Mr. Jean-Pierre Bemba today with Ms. Ines Pierre de la Brière. And Mr. Bemba has elected not to be present today. Thank you.
Thank you very much. And now for the defense of Mr. Kilolo, Mr. Canovas.
Good morning, Mr. President. Good morning, Your Honors, and good morning to everyone in and around the courtroom. Michael Carnavaz for Mr. Kilolo, along with Rosalie Beng and Ms. Tatarenko.
Was not so easy, Mr. Canovas. So, and then for the defense of Mr. Mangenda.
Good morning, Mr. President. Good morning, Your Honors. Christopher Gosnell for Mr. Mangenda this morning, who is not present, assisted by Nikki Sethi, legal assistant. Thank you.
Thank you very much. Before I give the floor to the parties for the submissions, I would like to make some clarifying remarks on behalf of the Chamber, where we stand today and what legal and factual circumstances we have to consider. Also that we have a structured discussion afterwards. We are here today because on 8th June 2018, the Appeals Chamber rendered its judgment on the main case against Mr. Bemba. The Appeals Chamber acquitted Mr. Bemba of all charges in that case. This was not done unanimously, noting that 2 judges wanted an acquittal proper, while 2 others wanted to uphold his convictions. As indicated in paragraph 73 of the separate opinion of Judges van den Wijngaard and Morrison, the 5th judge was, I quote, of the view that, rather than acquitting Mr. Bemba, he should have been sent for a retrial to a newly composed trial chamber, quote end. But as a consequence, Mr. Bemba is no longer detained in the main case. This is the basic here. However, in the present case, Mr. Bemba has been convicted for offences against the administration of justice under Article 70, paragraph 1a and c of the statute. These convictions have been upheld on appeal. They are final. Mr. Bemba's original sentence of 1 additional year of imprisonment and €300,000 fine was reversed and remanded following the prosecution's successful appeal. Due to the chain of consequences caused by the Appeals Chamber last Friday, the Chamber seeks today to urgently explore the question whether it remains justified to maintain Mr. Bemba's detention in this case while deliberating his new sentence also in this case. The Appeals Chamber directs as much, indicating in paragraph 200 of last Friday's judgment that, and I quote again, it rests with Trial Chamber 7 to decide, as a matter of urgency, whether Mr. Bemba's continued detention in relation to the case pending before it is warranted. So this is the issue we have to deal with today. Mr. Bemba is here in a situation whereby all the time he has spent in detention, pursuant to the warrant of arrest issued in these proceedings before this chamber, would need to be automatically deducted from the sentence of imprisonment this chamber would impose on remand. More specifically, noting that Mr. Bemba has been detained on the warrant in this case since 23rd November 2013, this amounts to over 4 years of potential sentencing credit. Article 70, paragraph 3 of the statute makes it clear that the maximum term of imprisonment which can be imposed against Mr. Bemba is 5 years. And the Chamber notes that the prosecution seeks this maximum term in its recent sentencing submissions on remand. Mr. Bemba's sentencing credit does therefore not exceed the maximum sentence available, noting also in passing that Rule 163, paragraph 3 of the rules removes the possibility of an Article 110 sentence reduction review after having served 2/3 of the sentence in the Article 70 proceedings. Consistent with the appeals chamber not automatically releasing Mr. Bemba and rather leaving the decision on continued detention on this trial chamber, Mr. Bemba is lawfully detained before this chamber as of this moment. The chamber would like to hear first from the Bemba defense, of course, who has already indicated that they seek to make an application for immediate release pursuant to Article 60, paragraph 2 of the statute. This is, as I'm sure the parties are aware of, but I assume that many people will listen today or will watch it and might not know all the provisions that are at stake. This is closely related to the legal question if the arrest of Mr. Bemba appears to be necessary with regard to the conditions set forth in Article 58, paragraph 1b of the statute. In this regard, the Chamber has taken note of the undertaking by Mr. Bemba in which he accepts certain conditions were he to be released. After the defense of Mr. Bemba, the Chamber will hear the prosecution's position on this matter before giving the Bemba defense a second and final word. Before commencing, the Chamber wishes to address two recent applications raised by the parties before proceeding to the substance of this hearing, and this also I think makes then sense for the other two defense teams that are present in this case. First, last Friday in request 2289, the Bemba defense noted the scheduled hearing time in order 2288 and invited the Chamber to consider the possibility of convening this hearing at an earlier date. The Chamber made efforts to try and move up the time of this hearing, and I think you will now know that we really made efforts and it was not really not possible to convene at an earlier time. The earliest time is indeed where we are sitting now. This request is rejected to the extent the Bemba defense sought an earlier hearing, but the Chamber appreciates the need for a swift ruling in this matter and can already announce that its decision on Mr. Bemba's continued detention will come tomorrow at the latest. Second, the Chamber notes the prosecution's request for leave to reply to the defense sentencing submissions in filing 2283. The Chamber considers that no further written submissions are necessary and that all of these matters can be discussed inter partes in a second sentencing hearing. And I think the defense of Mr. Kilolo and Mr. Mgenda will now listen carefully, and also, of course, Mrs. Taylor. The Chamber notes that Mr. Kilolo explicitly requested such a hearing. Given last Friday's appeals judgment, the Chamber anticipates that the Bemba defense may perhaps have also further submissions to make on the new sentence to be imposed. So we will have a second sentencing hearing, and this second sentencing hearing will happen on the 4th of July next month. However, this is not the opportunity here to engage in submissions of what Mr. Bemba's new sentence should be. The Chamber emphasizes again that the current status conference solely concerns Mr. Bemba's continuing detention while he awaits the renewed determination of his sentence. As I have already indicated, submissions are to focus on whether the three conditions of arresting Mr. Bemba in Article 58, paragraph 1b of the statute are met. Namely, if the arrest of Mr. Bemba appears necessary to ensure his appearance at trial, or to ensure that he does not obstruct or endanger the proceedings, or to prevent him continuing with the crimes, with the commission of the crimes he has been convicted for. I really ask the parties to center their arguments on these legal requirements. With these matters addressed, I give now the floor to the Bemba defense. I give the floor to Ms. Taylor.
Thank you very much, Mr. President. And I would like to just preface my submissions by expressing our gratitude for the efforts that were made by the Chamber to try and have the hearing at an earlier date. Today, pursuant to Article 60, subsection 2, the defence is requesting this Chamber to grant Mr. Bemba's immediate interim release to Belgium, where he resides with his family. By my count, this is the 15th request that has been submitted on Mr. Bemba's behalf since he was first arrested in 2008. And there are two prongs to our request today. Firstly, the grounds for custodial detention under Article 58 are not met. They were not met in January 2015, which is when Judge Tarfusa first ordered the release of Mr. Bemba, and they are certainly not met today. And secondly, the fact that Mr. Bemba has been detained for over 10 years in total and has served over 4.5 times his initial sentence is itself a special circumstance that militates in favour of his release. I would firstly like to address the burden of proof that concerns this application. Now, since Mr. Bemba withdrew his previous application, this is, legally speaking, the first determination that will be made by this Chamber under Article 60, subsection 2. The corollary of that is that the burden falls on the prosecution, not the defence, to justify that the criteria under Article 58 are met at this point in time. And that's consistent with the case law of this court. And if I can refer you to our table of authorities, it's the Katunga decision number 330, and that's at page 6 of that decision. Now, the fact that Mr. Bemba has been convicted in this case doesn't shift that burden of proof for the following reasons. The burden of proof is the corollary of the presumption of liberty into the statute. And for Article 17 offences, as this Chamber found in its oral ruling of October 2016, there is no presumption of custody that follows an Article 70 conviction. The statute says that the Chamber can impose a fine or a custodial sentence. So at this point in time, there can be no presumption that this Chamber will impose a further custodial sentence on Mr. Bemba. So given that he's already served 4.5 times the initial sentence, there can be no presumption of custody beyond this point. Now, in terms of the individual grounds under Article 58, firstly, his ongoing detention is not necessary to secure his presence for these proceedings. There will be no further evidential hearings in this case, as far as we're aware, even though if there's sentencing submissions, at this point in time, there doesn't seem to be any intent to call evidence or witnesses. And in line with the Chamber's oral decision of October 2016, if there are no appeals pending, the mandatory custody provision in Article 81, subsection 3 doesn't apply. So it doesn't follow from the statute that he has to be detained following his conviction. He's also not a flight risk. He has served any potential sentence in this case. Even if it is theoretically possible that the Chamber could impose a further 3 months, given that he has endured 10 years of detention, it is not logical, it is not rational that he would risk becoming a fugitive of justice for these 3 months. He is also requesting to be released to his home in Belgium, an ICC state party, to be with his wife and 5 children. And although he's been separated from them for over 10 years, he has, throughout his detention, maintained close links with them. And if I can refer in this regard to a report from the registry, which states that his family is of the utmost importance to Mr. Bemba, and he works hard to maintain his family links with his wife and children. And that's a main case filing 3375-Conf Annex 3, page 2, in our table of authorities. In its October 2016 decision, the Chamber affirmed, in relation to Mr. Bemba's co-defendants, that the existence of such close family ties reduces any flight risk. Belgium, a state party, has also demonstrated its willingness and its capacity to supervise Mr. Bemba's release and rearrest him if necessary. Belgium executed the arrest warrant against Mr. Bemba in 2008. It supervised 2 instances of day release during the main case. The registry reported that Mr. Bemba cooperated with the relevant authorities during his release. If I could refer you to filing, again, in main case filing 445, page 12, on our table of authorities. Belgium also enforced the arrest warrant against Mr. Kilolo and has supervised his release. And finally, Mr. Bemba has signed an undertaking expressing his willingness to surrender to this court if required for any purpose and to abide by any conditions imposed by this chamber. In terms of the second criterion, Mr. Bemba also does not present a risk to witnesses. The evidential proceedings have concluded, both in the main case and in this case. And on Friday, as mentioned by the presiding judge, the appeals chamber confirmed that the main case itself no longer presents a justification or a reason to continue to detain Mr. Bemba. In his undertaking, Mr. Bemba has, in addition, agreed not to communicate with any witnesses in this case and not to issue any public statements concerning this case and not to discuss the evidence of this case with any persons except his ICC lawyers. The third criterion concerns the risk that a person will continue to commit the crime or related crimes. Now, firstly, the statute refers to the word crimes. It doesn't concern offences on its face. Now, bearing in mind the extreme consequence of detaining someone, we submit that before extending this provision to offences, it's necessary to have concrete evidence and serious justifications for adopting such an extensive interpretation of the statute. Secondly, this case concerned interference with the main case, a case which is now closed. Mr. Bemba was acquitted in that case. There is therefore no objective risk that Mr. Bemba would continue to interfere with a final verdict that acquitted him on all counts. Now, the second prong of our application concerns the overall length of his detention, such that even if any of the criteria under Article 58 were to be fulfilled, this chamber would still have a duty to consider whether Mr. Bemba should be released in order to prevent unreasonable lengths of detention. Now, in January 2015, Judge Tarfusa found that Mr. Bemba's detention of 14 months was already unreasonable and disproportionate in light of the offences in this case. Although the decision was vacated by the appeals chamber, the appeals chamber did not overturn the specific finding of unreasonableness. The appeals chamber also confirmed the chamber's duty to balance any factors weighing in favour of detention against the defendant's right to be protected against lengthy detention. Now, here and now, that is over 3 years later, that balancing exercise favours Mr. Bemba's immediate release. If it was unreasonable for Mr. Bemba to be detained in January 2015, then it is certainly unreasonable for him to be detained in June 2018, 3.5 years later. Now, the reason that Mr. Bemba was not immediately released in January 2015 was because Judge Tarfusa attached a clear caveat. The decision ordered that Jean-Pierre Bemba Gombo be released from the detention centre of the court unless his detention is otherwise required. Mr. Bemba's Article 70 release was therefore never executed because there was a detention order in the main case. And because of this order, it was impossible to release Mr. Bemba in the Article 70 case and to lift the Article 70 detention order. As a result, whereas his co-defendants were released in October 2014 and were able to attend the trial as free men and are currently free men, Mr. Bemba was detained throughout in a maximum security detention environment. This main case detention order, this reason for this fundamental difference between his co-defendant's freedom and his detention, has now been vacated because of his acquittal on all counts. We can't walk Mr. Bemba back in time. We can't go back to January 2015 and give him this lost freedom, this lost time with his family. But we respectfully submit that it is possible to ensure that Mr. Bemba does not suffer further prejudice, that he does not endure any further unnecessary detention as a result of a case for which he was acquitted. We do not ignore the fact that last Friday's judgment, acquitting Mr. Bemba, it might be upsetting for some. We do not ignore the fact that many persons, including the prosecutor, have expressed their concern publicly with this outcome. But it is a verdict which is final. And like any other ruling of this court, it should be respected in full. And it is a verdict that has clear implications for the status of the length of his detention. He has effectively gone from having served 0 days of Article 70 detention to serving over 4.5 years, 4.5 times longer than the initial sentence imposed on him. Now, the appeals judgment on sentence in this case makes clear that he should be credited with any unused time that postdates his Article 70 arrest on 23rd of November. And that's paragraph 231 of that judgment. And it is the position of the defence, which we will seek to elaborate in further submissions, that the fact that he's been detained for over 10.5 years might warrant a different approach to punishment in this case. But for the purpose of deciding upon his release, it is not, in our submission, necessary to make a determination today as to either the exact sentence that should be imposed on him or the precise amount of credit that should be allocated. It is enough to demonstrate that any further detention would be unnecessary and disproportionate, and it would render the outcome of these proceedings a fait accompli. And human rights law says it would. Specifically, the Human Rights Committee has found that holding someone in preventative detention for longer than 1/3 the maximum possible sentence would be incompatible with the presumption of innocence, the right to be tried without undue delay, and most importantly, the right to bail. Now, if I can refer you to the authorities in our table of authorities, including General Comment number 32. International criminal law precedents also say that the judges have to be mindful that the length of detention does not predetermine the outcome of pending judgment and decisions. And at the ICTY, in the Rasic contempt case, even though the prosecution had a pending appeal against her sentence, the appeals chamber found that it was necessary to provisionally release Ms. Rasic during the appeals proceedings because she had already served her initial sentence and 2/3 of the sentence requested by the prosecution. The same approach was taken in the Herrikia and Marino contempt case. For Marino, the appeals chamber released him because he'd served his initial sentence, again, even though the prosecution had appealed. Similarly for Herrikia, the appeals chamber released him when he'd almost served his initial sentence, again, even though the prosecution had requested a 2-year sentence on appeal. That is a sentence that was 4 times longer than the initial sentence. In both cases, the appeals chamber found that the fact that the defendant had served or almost served the initial sentence was a special circumstance which could justify release. And this approach was even adopted in war crimes cases, where they found that the fact the defendant had served 2/3, and in some cases 80% of the initial sentence, justified release as a special circumstance. And if I can refer you to the Kovačka and Hadji Hasanovic decisions. In this case, we're not speaking about 1/3 of the maximum possible sentence. We're not talking about serving the initial sentence. We're not even talking about serving 2/3 of the maximum sentence requested by the prosecution. We are speaking about a case where Mr. Bemba has been detained in a maximum security environment for 9/10 the maximum sentence that can be imposed by this court for any form of contempt. Accordingly, unless Mr. Bemba is released today, he will end up serving that maximum sentence by default, rather than by virtue of a reasoned and impartial judicial determination as to appropriate sentence. And he will have served the whole sentence. And even if, under the statute, defendants can't apply to the presidency for early release, that would not normally preclude them from applying to national authorities for early release if they were serving their sentence after conviction and released to do so. Now, obviously, the Chamber could not predict Mr. Bemba's acquittal in the main case. And because of the existence of the main case detention order, steps could not be taken by this Chamber to address or eliminate this risk of over-incarceration and over-punishment. But today, the outcome is now known. The appeals chamber has stated clearly that his detention is not required for the main case, and that acquittal is final, and it should be meaningful and not illusory. This honourable trial chamber now has the exclusive power and the responsibility for protecting Mr. Bemba's right to liberty, and steps can now be taken to address this issue of over-incarceration and over-punishment. Mr. President, Your Honours, given Mr. Bemba's main case acquittal after 10 years of detention, given that Mr. Bemba's co-defendants are at liberty and have been since October 2014, given that Mr. Bemba has served 4.5 times the initial sentence and 9/10 of the maximum possible sentence under the statute, given that he has undertaken to surrender to this court should any further detention be required, we respectfully submit that there's no legal or objective justification to separate Mr. Bemba from his family for 1 day further. We therefore request that he be immediately released to Belgium. Thank you.
Thank you very much for the prosecution, Mr. Gurilla.
Thank you so much, Your Honours. The position of the office will be summarized, will be presented by Ms. Regge. I will just make a couple of points by means of introduction related to the implications of Friday's judgment for this case. And I have heard with attention Mrs. Taylor's arguments and her plea that this chamber somewhat affect or give consequence to the acquittal entered by the majority of the appeals chamber on Friday. And Your Honours, I would remind the chamber of the position that this office has taken from the outset of these proceedings. This is an autonomous case with an autonomous level of gravity, with different offences that have their own weight and their own consequences. It's not subservient to the main case. It's not an appendix to the main case. Certainly the jurisdiction of this trial chamber is not subservient to the decisions of the appeals chamber in a separate case. That position was the position before Friday's judgment. It has not changed. It's the same position that we're going to argue before you today. Any decision by this chamber must be governed by the specific circumstances of this case, by the applicable legal framework to the specific juncture we're in this case, and by the specific factors that the chamber has to consider in this case. In this sense, what the appeals chamber has decided in a different case is of undoubtedly significance for that case and for this institution, perhaps, but not for what you have to decide right now. So the two issues for you to decide first is whether the release provisions are applicable at all to the current situation. And as you will hear from Ms. Regge in a second, our position is they are not. And the second question is whether if those provisions are applicable, by means of hypothesis, whether they would lead to this trial chamber ordering release. As I said, these are the factors that the chamber has to consider. We will not allow our position in relation to Friday's judgment to taint our position here. In the same way, conversely, we should not allow, basically, the defense's undoubted and clear satisfaction with Friday's judgment to basically push for a decision by this chamber on a separate case that has its own degree of gravity, its own circumstances, and its own weight, which cannot be set aside so lightly. So without further ado, Your Honours, I'm going to give the floor to Ms. Regge.
Good afternoon, Your Honours. As instructed in your order, Our submissions will focus on the continued detention of Mr. Bemba in this case. In addition, we will briefly address some of Mr. Bemba's remarks regarding the appeal judgment issued on 8 June 2008 in the main case. As your honors have mentioned, on 8 March 2018, the appeals chamber confirmed the convictions of Mr. Bemba with respect to offenses under Article 71A and C. The convictions are final. Mr. Bemba has been found guilty and he no longer benefits from any presumption of innocence in this case. Therefore, Article 60 does not apply at this stage of the proceedings, nor does Rule 119 regarding conditional release. Besides, if the rule was to apply, Mr. Bemba's undertaking is clearly insufficient. He should identify, and he did, but a state where he wants to be released, but also that the state should be consulted. In application of Rule 119.3, the court should seek observations from the relevant states. Your honors follow this procedure in your decision 1151 of 17 August 2015, when you decided on the conditional release of the other 4 convicted persons before the start of the trial. Mr. Bemba has been in detention pursuant to an arrest warrant in this case since 23 November 2013. That is over 4 years. As Mr. Bemba notes in his urgent request, paragraph 2, and the appeals chamber has confirmed in the sentencing appeal judgment of this case, paragraph 231, Mr. Bemba is entitled to have this time deducted from the sentence that your honors might impose. The prosecution has requested Mr. Bemba to be sentenced to 5 years imprisonment in addition to a substantial fine. If the chamber follows the prosecution's submissions and imposes a sentence of 5 years, Mr. Bemba should still remain in detention to serve the remainder of the term that he has not served. Since there is no review of sentence for Article 70 offenses, any sentence must be served in full. In short, your honors, Mr. Bemba must remain in detention until a sentencing decision is issued. However, the prosecution will support an expedited resolution of the sentencing proceedings with respect to Mr. Bemba. We were willing to withdraw our request for leave to reply, notwithstanding our position on the merits, so your honors could proceed with a decision on Mr. Bemba's sentence with reasons to follow. Your honors could also separate the sentencing proceedings of Mr. Bemba from those of the other convicted persons to expedite the resolution of the decision on Mr. Bemba's sentence. Notwithstanding that our main position is that Article 60 and Rule 119 do not apply to this situation, we will address, your honors, the conditions under Article 58(1)(b). We will focus our submissions on the first requirement, the necessity to ensure the person's appearance in trial. We concede, your honors, that the lapse of time since the offenses took place and also the appeal judgment issued last Friday by the appeals chamber are factors that may attenuate Mr. Bemba's intention to abscond. However, there is still the possibility that he may do so. This cannot be discarded at this stage. I refer, your honors, to the updated report on Mr. Bemba's solvency from the registry. That's filing 0105, 0113, 2278, Annex 1. Also, your honors, Mr. Bemba's conviction for offenses against the administration of justice have been confirmed on appeal. And it's clear that Mr. Bemba played an essential role in corruptly influencing at least 14 witnesses through, inter alia, the authorization of payments. These offenses took place between October 2013 until November 2012 until November 2013. Mr. Bemba had the means, as recent as November 2013, and the capacity to mobilize a network of supporters to perpetrate offenses. Hence, we cannot discard the possibility that he will use these resources and this network to abscond. I refer Your Honors as well to the warrant of arrest issued by the single judge on the 20th of November 2013. The single judge confirmed that Mr. Bemba continued to have political connections, even at an international level, and noted the substantial nature of the financial resources available to him, directly or indirectly, for the purposes of committing offenses. Trial Chamber 3, in the main case, reiterated on the 23rd of December 2014, that's in decision 0105, 0108, 3221, paragraph 25, that Mr. Bemba benefited from financial and material support. Even last Friday, Judge Vandengaard and Judge Morrison, in their separate opinion, considered that Mr. Bemba would not be released if they would have ordered a retrial, as Judge Eboe Osuji had preferred. That's it. The appeal judgment 0105, 0108, 3636, Annex 2, footnote 57. Hence, they implicitly acknowledge that the conditions underlying detention will be met in the event of new proceedings at this stage. Very briefly, Your Honors, I would like to address some of Ms. Taylor's remarks in her urgent request and today. We submit, Your Honors, that the majority's appeal judgment in the main case has no impact on the quantum of the sentence to be imposed on Mr. Bemba. These two cases have always proceeded separately. Our sentencing submissions filed on 30 April, that's filing 2279, remain equally relevant. The gravity of the crimes and the culpability of Mr. Bemba for the crimes for which he was convicted in this case remain the same. So does the need of the sentence to reflect it and to have a deterrent effect. For the convictions in this case not to be inconsequential, he should be sentenced to 5 years. He should also be sentenced to a substantial fine. Since there will be no reparations in the main case, the prosecution's previously expressed concern that there will be not sufficient funds to cover legal aid no longer exists. Neither the majority's appeal judgment nor the time that Mr. Bemba has spent in detention pursuant to the arrest warrant in the main case are relevant factors to determine Mr. Bemba's sentence in this case. The fact remains that Mr. Bemba was lawfully arrested and has at all times been lawfully detained in the main case pursuant to a valid arrest warrant. And finally, Your Honors, contrary to what Mr. Bemba suggests in his urgent request, that's in paragraph 3, is this not accurate that Mr. Bemba has been acquitted of all the charges that the prosecution brought against him in the main case? He was only acquitted of approximately half of the criminal acts, that is in paragraphs 118 and 198 of the majority's appeal judgment. With respect to the remaining of the criminal acts listed in paragraph 116, the majority considered that they fell outside of the charges, reversed the conviction, and discontinued the proceedings. That's in paragraph 197. I thank you, Your Honors.
Thank you very much. Ms. Taylor, do you want to make additional remarks, or do you want to answer?
Thank you very much, Mr. President, Your Honours. I'd firstly like to address this issue of Mr. Bemba's acquittal in the main case and the relevance it could have to the specific criteria under Article 58. Now, firstly, yes, these are two separate proceedings, but this chamber found, and the appeals chamber upheld, there was a link between the detention orders, that the Article 70 detention order could not start because of the main case detention order. So the reality is that if last Friday's acquittal had come earlier, we could be having this hearing earlier. This issue of predetermination would not be so exacerbated. There would not be a risk, such a risk of over-punishment, either over-punishment in this case or de facto punishment in the main case. So there's that linkage, firstly. Secondly, human rights law states that a fluxion of time is relevant. The longer that someone's in detention, the less likely it is there'll be a flight risk. Now that logic applies irrespective as to the legal status of the detention order. If Mr. Bemba's been in detention for 10 years, he's not going to risk his livelihood, he's not going to risk his family, he's not going to abscond from justice for 3 months. So yes, that 10 years is relevant to the risk. It's also relevant to proportionality. He's been separated from his family for 10 years. So that is also a factor that impacts on the urgency of today's application. So there's that relevance. Yes, Mr. Bemba's conviction in this case was confirmed. But something that has not been referred to thus far was that he was acquitted of a third of the charges in this case. So the exact extent to which that must be balanced against the two errors identified by the appeals chamber has yet to be determined by the chamber. And that's the issue we're facing today, that element of predetermination, that can't be predetermined. Now, the prosecutor has suggested today that we could have an expedited resolution for Mr. Bemba. But that strikes at the heart of the issue, that he would be afforded less time to prepare as a consequence of his detention. He would be prejudiced, yet again, as he has been throughout this case, as the only detained defendant. He should not have to choose between liberty and a right to preparation. The way you reconcile that is through his release. Now, he has quite clearly stated he wishes to be surrendered to Belgium, but we are willing, of course, to provide further written assurances and guarantees as to the exact location of his release. And I think in the past, this chamber has released the defendants without going through any further need to have a hearing to hear from Belgium in this case. So we think that's a red herring in that regard. Now, in terms of the applicability of Article 60, the ICC has already found, in connection with one of Mr. Bemba's 15 provisional release applications, that Article 60 can still apply at the trial stage. And if it can apply at the trial stage, it can also apply at this point. The question is not the stage of the proceedings, it's the right to release and whether detention is justified. Now, if I can also refer to Article 81, subsection 3b, that specifically envisages that someone on appeal can apply for release if they've already served their sentence. So the statute specifically envisages that the right to release applies throughout. It's not somehow exhausted because of an artificial distinction concerning the phase. Another issue that's been brought to bear today is, of course, the fact that under the statute there's no explicit right to apply for a 2/3 release. Well, we would also say that Rule 163 specifically excludes Article 106 of the statute. Now, what that normally means is that if someone's released to a national state to serve their Article 70 offence, imprisonment, this court doesn't supervise that under our statute, which means that if Mr. Bemba had been released to Belgium when the sentence in this case was first handed down, he could apply for release under Belgium law, which is potentially at a 50% mark or a 2/3 mark. So yet again, he shouldn't be prejudiced by virtue of the fact that he served almost the entirety of a maximum possible sentence here rather than in a national setting. Now, in terms of the individual criteria under Article 58, even though the burden falls to the prosecution, we haven't heard any concrete indicia as to how the criteria are fulfilled in this case. And again, the appeals chamber has affirmed it's not enough to simply reiterate the findings in an arrest warrant decision. There's a duty to make a reasoned determination at the time of the application as to whether the criteria under Article 58 are met. The fact that they were met in 2013 does not dispose of the issue, because if it had, Judge Tarfusa wouldn't have released him in January 2015. That's the same judge. And as I mentioned, the appeals chamber has specifically said that even the judges can't simply refer to their previous arrest warrant decision, because that would render Article 60 nugatory. And again, we've heard brief references to his solvency report with no indication as to how that's relevant to his cooperation. To someone who has indicated quite clearly he will cooperate with this chamber. He will agree to abide by any conditions imposed by that chamber. So given these circumstances, given the burden of proof on the prosecution, and given the overall length of time, the prosecution has failed to substantiate how his continued detention is necessary and how it's reasonable and proportionate. Thank you.
Thank you. So, this concludes the status conference. As previously indicated, the Chamber's decision on this matter will be rendered by tomorrow at the latest.
All rise. We will obey.